handling dispute from cross-border contracts. So our panel guests are first Daria. So she's a dual qualified lawyer, admitted to practice in Russia and France. We have heard from yesterday there are quite a few speakers of our of us who have talked about results from the research of Center of the Queen Mary University of London. And she, Daria, is one of those researchers at the Center of Commercial Law Studies at Queen Mary University of London School of Law. She has been worked as arbitrator for a long time in several arbitration law firms in Paris, but also she has worked since 2012 as deputy counsel in Eastern European team of the Secretariat of the ICC Court of Arbitration, and now she's on leave and based in London. So, and we have Chris, the second speaker, and I myself the third. So maybe I can invite, allow me to invite Daria to deliver your first speech for us. Thank you.
Hello, I'm very happy to be here today. Just a little remark, I didn't work as arbitrator. I've worked in law firms, but I've never been an arbitrator. So my specialization is more to manage the disputes. As it was said, I used to be a deputy counsel at the ICC Court of Arbitration, so I can bring some input from the inside to the extent of possible. And if you have any questions, practical questions, I will be happy to answer. As for now, I'm a researcher at the Queen Mary University of London, and my research is aimed at state contracts and energy contracts as state contracts. So it's a mix of commercial and investment arbitration issues, which I find very interesting. But now let's go to my presentation. Just a little technical.
Just turn it.
Turn it like that?
No, just.
I see. I'm sorry. Okay. So as you can see, today our topic is avoiding disputes and handling disputes. As I said, I'm more specialized in handling disputes than avoiding disputes. But sometimes it's important to know how to handle disputes in order to avoid them. The main issues, when people speak about avoiding disputes, it's of course, there are some matters which are out of our reach. We know that when parties have long-term commercial relationships, they tend to negotiate between them to have the special people who deal with these issues, and we don't see all that. Even when we work at the international organization, we cannot see that, because when they come to arbitration, it means that it didn't work. And for instance, for such contracts as long-term gas supply contracts, when the parties come to the arbitration, it means that it really, a long negotiation process didn't work at all. And I've seen, when I was working at the ICC, I've seen a lot of disputes related specifically to gas price readjustments, and it's very, very tricky issues, because parties continue to work together, they continue to supply, but at the same time they have these problems on the price, so it becomes very sensitive. And one of the legal possibilities to ensure that the parties will negotiate is the multi-tier dispute resolution clauses, which specify that the parties should go to mediation or conciliation before reverting to the dispute resolution. Here you have an example of such clause. It's an example of a clause providing for mediation before going to arbitration. The problem of such clauses is that courts in a lot of countries don't think that they should be enforced. So unless the parties really put a very much detailed description of their negotiation process, it doesn't work. For instance, in this case, the English court said that this is not precise enough, and this is not a bar for the parties to go to the arbitration. Sometimes people say that this kind of clauses are the clauses which prevent the courts from the arbitral tribunals from having jurisdiction. I don't think that this is the right formulation, because it's not about the jurisdiction, it's about the admissibility of claims. If the parties negotiate or try to negotiate, the claim will be admissible and they may go to arbitration. The problem of these kind of clauses is that if it's very vague, the parties may find themselves with the obligation to negotiate for an unlimited amount of time. Then it's not clear whether they fulfilled their obligation to negotiate and to agree. So be very careful. If there are lawyers who conclude contracts in the auditorium, be very careful about such kind of clauses. Okay, so these are positive and negative sides of this. Positive sides, they're very common, but the negative sides, as I said, waste of time, increase of expenses, and from my point of view, the most dangerous is this damage to interim measures, because sometimes you should be very quick, act quickly, and if you try to negotiate, it may affect your ability to use the interim measures and other relief. So now let's go to the second part, the handling of disputes. I can say that even if I worked at the arbitration organization, I don't personally think that arbitration is always a good thing. I've seen very interesting cases where the parties suffered from their decision to go to arbitration. For instance, in one of the cases, the amount in dispute was $5,000. $5,000. So they went to ICC arbitration. ICC, it was 2014, so now they have the simplified procedure. But before going with $5,000 to ICC arbitration, it means that you will have to pay for at least $15,000, depending on the hours of the arbitrators. And sometimes it's not possible. There are some countries where it's not possible to enforce, so you will have your claim, you will have the decision, the country will be a party to the New York Convention, but practically you cannot do anything with this award, because the party may have been restructured, the government may have changed, as it happened to Ukraine. So it's not always a good choice to go to arbitration. As I said, the decision will depend on these factors. So amount in dispute, who the parties to the contract are, location of assets. Unfortunately, some countries change from quite arbitration friendly or not very arbitration friendly to completely arbitration unfriendly. That's what happened with Russia, unfortunately. So when I started to work at the ACC, we used to have very few Russian-related cases. Probably out of 90 we had probably 5. In 2015, I had out of 90 already 50 Russian-related cases. And it's all thanks to work the ICC did in Russia. People started to include ICC arbitration clauses in the contracts. But then the problem is that now Russia changed its arbitration law which became quite unfriendly. So now it may be quite problematic to enforce these awards if the assets are on the territory of Russia. And it's the same with London. It's not only, as it was said before, that London is a place de prédilection, the favorite place for Russian-related arbitration. That's true. But now it's not only the problem the countries are having between them, but also the anti-arbitration trade in Russia, which will affect it. I think we will see what will happen after. That I covered the possible enforcement confidentiality requirement. It's true that the arbitration may be chosen because of its confidentiality. And when you open a book on arbitration, it's always one of the main points, confidentiality. From my point of view, the problem is that arbitration often ends in the courts when the court enforces the award. So the problem is that it may not become as confidential as the parties would have wanted before. The other problem is the arbitrability of disputes. Some countries are very friendly to arbitration, such as France, so a lot of disputes are arbitrable, even, for instance, disputes relating to public contracts, administrative contracts, they are all arbitrable. In other countries, a lot of disputes are not arbitrable, and it creates a problem for arbitration. The award will be annulled or just not enforced. So what is important for me as well is to know that sometimes when you decided to go to arbitration, it's better not to invent things, because some people, they want to go so much into the details that they create a completely unenforceable arbitration clause. For instance, in my experience, I saw once an arbitration clause which was providing for the arbitrator qualified in the UK and in Russia, but at the same time speaking French and Spanish. So, and it was a very heavy construction dispute. So probably you will find this person, these people exist, but it doesn't mean that this person will be highly qualified in your dispute as a construction dispute, or if we talk about the gas price readjustment dispute. The problem of the gas price readjustment disputes is that there's a very small pool of arbitrators. They're quite old people, and they don't speak several languages. So sometimes, or even always, it's better to just choose an arbitration clause from the model. Every arbitration organization has a model arbitration clause. LCA has it, ICC has it, Stockholm Institute has it. So it's always better to insert in your contract the model clause, and then the organization will help you if there are some problems. These are examples of the model arbitration clauses. You can see that they are pretty much the same. So now, due to the competition and the fact that the disputes are so globalized, different arbitration institutions just follow the same road, I would say. So it depends more on practical issues of your case. As it was said, sometimes Paris is less expensive than London, but I have a preference for London, even if I lived for 10 years in Paris. I do think that London lawyers are one of the best in the world, very well organized. So they don't have a Latin flavor that you can see in Paris sometimes. This is my personal opinion, nothing personal. So, as I said, use the model arbitration clause. If you decide not to use it and invent something, there are some issues you have to resolve, what you want. So you can see ad hoc or institutional arbitration. Does everybody here know what it is, ad hoc or institutional arbitration? So I won't go further. Ad hoc arbitrations, they may be very, very problematic at the end because you should just reinvent everything and it's always stuck. For instance, we had cases of ICC as appointing authority for ancestral cases, and sometimes people, they think that they do the ancestral arbitration, but in fact they just insert their thing and it ends in nowhere. When they try to write their own rules, it may be 3 pages of arbitration rules, but it's still not enough. It's still not the arbitration rules. It's still not the organization. There are no people helping you. So be very, very careful with ad hoc. But I think that now it's not a trend to use the ad hoc arbitration. I haven't seen it in a while. So after that, you decide what arbitration institution you want to choose. If you want the institutional arbitration, I think it depends. I do think that the Brexit will help the LCIA actually, because London will become more independent of the European Union. There won't be regulation applicable, and it will help the investment arbitration as well. So after, you just should decide probably logistically what is better for you and decide on the arbitration institution. Then place of arbitration. If you forget it, it's not a problem. Normally the arbitration institution will decide for you, but you may end with something you don't want. Because how it happens, for instance, at the ACC, if you don't have the place of arbitration. You don't have a place of arbitration in your contract, so the court will decide for you. What is the court? The court is 3 persons at the court session. So 3 independent lawyers who are members of the ICC court will come, they will look at your case, they will think what's appropriate, or probably you just mentioned something, not think that it will be one of the factors for your place of arbitration. For instance, you can say, we will conduct the hearings in Paris, but as there are no other indications, the court will say, well, they want to conduct hearings in Paris, probably they want to have place of arbitration in Paris, you see? So people will decide for you, and it's quite subjective, as you can see. Then, number of arbitrators. The general rule is that if there is no indication on the number of arbitrators, the ICC court, for instance, decides for 1 arbitrator if the dispute is not big enough. Then the problem with 3 arbitrators, not a lot of parties understand that it multiplies your costs by 3. It means that for a quite small arbitration case, you can end with very high arbitrators' expenses and arbitrators' fees because you will have 3 instead of 1, and actually you don't need it, but you put it in your arbitration clause. And funny enough, a lot of people think that institutional arbitration is expensive because of the institution itself, but actually the 70% of the arbitration costs, if I don't speak about legal advice costs, it's fees and expenses of arbitrators. Arbitration institutions try to put them down, to decrease them as they can, but sometimes it's just not possible. So the fees and the expenses are the 70% of the cost of your arbitration. So it's possible to do the arbitration quite cheap or cheaper as people generally do, but you should think in advance. Because once you put 3 arbitrators in your clause, and when you're in a dispute with the other parties, if they don't have quite qualified lawyers, they will just not go. They will not agree with you on anything because they will be in this war attitude, right? So it's better to, if you put one and then you decide that it's not enough, you can probably after negotiate for 3, but so it's quite difficult. Always look at the, sometimes very interesting clauses are, and quite intelligent, I think. Sometimes parties put, it will be 1 arbitrator up to $5,100, for instance, and it will be 3 arbitrators after $100,000. That's a good idea because you know that if the case is expensive, you will pay more, but you won't pay a lot for a small amount in dispute. Do you know how the fees of arbitrators are calculated? So normally the arbitral institutions, they have this calculate on their websites. So you can go and put the number of arbitrators, the amount in dispute I think will be, and it will give you the approximate fees for arbitrators, but then it will add the expenses. Language of arbitration. So it's better to insert the language as well in advance, but if it's not done, the court will decide for you or the arbitral institution. We'll see. There's a place of arbitration. I covered everything on my own. So, numbers of arbitration. So you see here the ICC rules, the choice of sole arbitrator. Language of arbitration. So I used to have a horrible case where the parties couldn't decide on the language of arbitration. It was very interesting because the language of arbitration wasn't in the contract. It was a gas price readjustment dispute as well, so very high. The contract was in 2 languages, Russian and English. So the claimant, Russian entity, appointed a Russian-speaking law professor who didn't speak any English at all. I called him, I helped him. Sometimes the arbitrators, they should fill in the form to be an arbitrator. So we sent him the form in English. He couldn't translate. He was around 70 years old. I called him, I helped him personally to fill it in, so he was able to conduct arbitration in Russian, but no possibility for him to do it in English. The other party appointed an English-speaking arbitrator who didn't speak any Russian. So it ended, before it was decided, it ended in a long series of submissions on the language of arbitration. Each party writing in the language they thought they would use, which will be the language of arbitrators. So the claimant was writing in Russian, respondent was writing in English. So respondents' lawyers had some extra expenses for translating everything into English. So it's better to put the language in your contract. It will save you money.
What was the result?
Sorry?
What language was ultimately determined?
It was English at the end. I think it was decided English because of the nature of the dispute. As I said, for gas price readjustment, very specific area, right? So not a lot of Russian-speaking lawyers as qualified in that. So finally, the reason came to the claimant and they appointed. But it was just a tactic, right? It was a tactic to delay. They wanted to delay because it was 2015, the gas price fluctuations, if you remember how it dropped dramatically. So everybody, they needed time. But don't give the other party this opportunity, because they will take any opportunity. right? Oh, applicable law. Applicable law is another, it's a huge issue to discuss. I won't make a presentation on applicable law here, but the problem is that the applicable law is decided also by the arbitrator. So if you don't put the applicable law in your contract, you will end up with somebody else deciding on how to resolve your dispute. And the problem of a lot of countries, for instance, it's not a problem, but the fact is that, for instance, in France, they don't rejudge your case, right? So the decision made by the arbitrator won't be questioned. That's why it's always better to decide what law you want to see applicable in your contract. Interestingly enough, arbitral tribunal in the ICC rules, for instance, shall apply the rules of law which it determines to be appropriate. People don't think about what it means. Rules of law. Rules of law means that, for instance, if the arbitrator wants to apply lex mercatoria, whatever it is, lex mercatoria, to a contract, unless he goes ex aequo and bono, lex mercatoria is considered to be a rule of law. So it may be a possibility as well if the arbitrator is inventive enough. That's why my personal opinion is that when you negotiate your contract, you should think about dispute resolution, not to put it at the end as it happens very often. And it's better to take the model clause, to think about the law you want to be applicable, and have it in your contract before the problems appear. That's all for today. Thank you very much.
Well, thank you very much, Daria, and thank you all. So now we move to Chris. Chris is a partner in Baker Bott's litigation practice group based in the London office. He has worked a lot both in commercial law advisory and also in arbitration or litigation, and has advised quite a few large, giant companies, like some well-known companies based in Silicon Valley, for example. For example, one of the companies who provides the most widely used social media platform, and it is used by all people around the world, except China, I mean. And Chris is also a mediator at the Center for Effective Dispute Resolution. Now, Chris, welcome.
Morning, everybody. I have a presentation. Unfortunately, we don't have it on the screen, so it will just be me, but it was a relatively brief presentation anyway. The session is about handling and avoiding disputes in cross-border contracts.
It's just for the cameras, it has to be.
Oh, right, okay. I think because of the scale of the room, I need to be projected on the microphone. Okay, that's fine. As a disputes lawyer, I'm going to concentrate on handling cross-border disputes. We're not particularly expert in avoiding them. That's not really very good for a long and fruitful career as a disputes lawyer. So I'll be talking more about the handling side than the avoiding side. I want to start off by talking about enforcement. I think when at law school we all learn about dispute resolution, international dispute resolution, then because enforcement's at the end of that, then that tends to get left to the end, and we talk about the process and the witnesses and disclosure, and then the award or the court's judgment, and then enforcement gets pushed off because it's the last bit. But actually it's the most important bit, because there is no point having a shiny arbitral award or a shiny court judgment and then not being able to transfer it into money, particularly because you've probably spent a lot of money obtaining that judgment or that award in the first place. And so I think it's very important before starting off any cross-border dispute to look at, is enforcement ultimately realistic? And that goes to looking at where the counterparty has got assets, and also whether or not your court judgment or your arbitral award is going to be readily enforceable in those places where your counterparty has assets. Because if it isn't going to be readily enforceable there, there's not much point getting your award or your judgment. The other thing to look at is it may well be the case that the counterparty has got assets there at the moment, but will they still have assets there in 2 years' time when your case finishes? And looking at how easy is it in those jurisdictions for people to shift assets in the interim and to unwind that shifting of assets that may have happened in the interim, because the counterparty may well be anticipating you'll get a successful judgment or award against them, and will be taking steps in those jurisdictions to move the assets around to make the enforcement more challenging. And it's important to bear in mind that those sorts of battles can be extremely expensive. Trying to reverse asset transfers is not something which is straightforward in most jurisdictions. And so when you're costing your dispute and when you're going to your board of directors or to your client and looking at dispute costs, really stress test with lawyers in those local jurisdictions where you're going to want to enforce, how much is that enforcement process likely to take, particularly if the counterparty is really quite difficult or shifty in terms of how they deal with their assets. If you're up against ICI, it's probably not a big concern, but you may be up against some fairly shadowy opposition. This sort of thing happens fairly regularly against those sort of counterparties. One thing that's also quite important, I think, early on, is to look at using asset traces. I don't know how much experience of that there is in the room, but quite often in jurisdictions, there's not a lot of publicly available information in relation to where assets are and how those assets are held. And there are some very good asset tracing firms out there who can do quite a lot of work to establish what assets might be available. And I think whilst it's an upfront cost, it's often money that's quite well spent to try and determine what assets there might be. It's also quite useful if that counterparty starts shifting assets to be able to establish, well, look, as at this point, before we started the dispute, this was the asset position, and this is the asset position now, and that shows that there's been a deliberate effort to shift assets to make enforcement more difficult. We've touched on this briefly, but again, on the European Brexit position at the moment, it's very easy to enforce English court judgments in the rest of the EU and vice versa. That may not be the case, depending on what exit deal we have. So again, that's something to bear in mind. If you've got something which is a European cross-border dispute, don't assume that it's going to be as easy in 2-3 years' time to enforce that judgment as it would be at the moment. So something to bear in mind there. Oh, here we are. Okay. Couple of thoughts, further thoughts on enforcement. Because of this risk of asset shifting and the difficulty of enforcing in due course, one thing I think is very important to look at very early on is whether or not you can get some sort of freezing order relief in jurisdictions where there are assets to prevent the shifting of those assets during the course of litigation, during the course of the arbitration. The English court jurisdiction is quite interesting on this. It used to be that you had to show a risk of dissipation of assets, which is quite a difficult test. I mean, really, unless you can show that the counterparty has shifted assets in the past, it's quite hard to show that there's a risk that they're going to dissipate going forward. More recently, the case law has moved towards whether or not the counterparty has shown dishonesty. Now, that may be rather easier to establish. We had a case recently where we started off the case and we didn't have sufficient evidence to show that there was dishonesty or a risk of dissipation, even though we suspected that. We issued the claim and the counterparty filed a defence in which part of his defence was he didn't understand what he was signing because he didn't speak any English. This was a Russian gentleman. We then, from YouTube, found a clip of him speaking perfect English at a golf tournament. So we moved for summary judgment in relation to his defence on this point, but we also went to the judge and said, look, this guy's dishonest. Here he is, he's pleading a defence, he's putting a statement of truth on it, saying he can't speak English, and he can speak English. And that gave us the springboard to get a freezing order, whereas before that, even though we didn't have much faith in this chap, we didn't have anything you could really hang your hat on that. So look very, very hard at whether or not you can get some sort of freezing relief. Also, some jurisdictions are surprisingly ready to grant freezing relief. So if anyone here is litigating the Cypriot courts, basically in Cyprus, if you're the claimant, you can normally get freezing relief provided you post a bond. So without having to show the risk of dissipation or the dishonesty. So really stress test where those assets are, whether or not you might be able to get some sort of supportive freezing relief. The other thing, if you're in the LCIA, there is the potential to get security for claim in the LCIA, which is quite an unusual provision. Not an awful lot of guidance or quite a lot of freedom to the tribunals to where to grant that. So again, if you've got a counterparty where you might be able to show a risk of dissipation or a risk of an inability to pay the award in due course, then look quite hard if you're in the LCIA at whether or not it's worth making one of those applications. And also from a settlement perspective, if you've managed early on to get some kind of ring fencing of assets, your chance of getting a favourable settlement is greatly increased than if the counterparty is always thinking, well, look, you may well get your award in due course, but I'll just dissipate my assets and you won't be able to enforce against me. One thing that we see quite a lot is special purpose vehicles as the contracting counterparty. So you've got a cross-border contract and the other side is using a special purpose vehicle without really any assets in it. And so an example we had quite recently, Russian gentleman in London, different case than I was talking about before, purchasing a business that basically operated in the Ukraine, and he was using a BVI special purpose vehicle that he was going to put the money into the day before completion. It would complete and it would be the owner of the asset. There was a gap between exchange and completion, and in that gap, the Ukraine crisis started. So this is around about sort of 2014. And so the value of the asset dropped significantly between when the exchange contracts at a certain price and when he was due to complete. So the decision was taken, well, we won't complete on the contract, we'll just breach the contract, and you guys can't do anything because it's a special purpose vehicle, it's got no assets in it. Well, that's not quite true, because he was effectively procuring that special purpose vehicle breached its contract. And in most jurisdictions, there are provisions which make that a tort. And so that opens up a tort claim against the ultimate beneficial owner, the ultimate controller, who has got assets and may well be in the jurisdiction. So when you're dealing with entities with no assets on the other side, take a close look at who's controlling those entities, because quite often they'll just be nominee directors, and you'll be able to show a causal link in terms of procuring that breach of contract.
But how far the courts are ready to go, for instance, in the UK?
Well, normally what
Well,
happens...
it's like a pyramid of,
Yeah, and normally what happens actually is you end up with the jurisdiction over those disputes being in the BVI or Cayman, because that's where the tortious act is effectively causing the damage. And there's reasonably good authority there, and quite a few cases where that's actually sort of happened successfully. So there is and the jurisdictions differ a little bit, but it's certainly a sort of credible line of argument to advance in those jurisdictions. I've not seen it too much run in the UK, just because that special purpose vehicle doesn't tend to be UK based ordinarily. Final point on here, the cutting losses can be hard to do, but beware of throwing good money after bad. And the commercial guys will often come to you and say, look, this contract's been breached, we're furious about this, we want to send a message, and there's normally a lot of anger within the organisation early on in a dispute that we can't just have people breaching contracts with us. Be careful not to get too swept along with that, because there is no point, if it's going to be very difficult, enforcing at the end of this, spending hundreds of thousands, millions of pounds pursuing this, and then not converting it into cash, because you're just making a bad situation worse. And sometimes, the wisest counsel and the more difficult counsel can be say, look, we've got to draw a line under this. This is not something which is a sensible use of our funds, because we won't be able to convert at the end of it. So I'd say don't be shy about that if it looks like the enforcement route is going to be very difficult. So quite often, if you have an international contract, you will be in either an international tribunal, so not in your domestic jurisdiction, or in a foreign court. And if you do have your own, if you're lucky enough to have a sort of jurisdiction you're used to dealing with, all well and good, but quite often it is an alien jurisdiction. And in those circumstances, I can't stress enough how important it is to really try at the beginning of the process to understand what that process entails. And I do a lot of litigation in helping clients with litigation in foreign legal systems, and the degree of divergence from what one would see as the norm is colossal, even within Europe. A Swiss claim compared to an Italian claim compared to a Swedish claim, hugely different. And there is a risk of just concentrating on how much is it going to cost and how long it's going to take, and okay, I understand what's going on. You need to stress test much more deeply than that, how this claim will play out, what sort of tactics are likely to be involved, what kind of applications will be made. Don't take anything for granted. Don't assume anything is going to be like your home jurisdiction, and work really, really closely with your local lawyers in those circumstances to understand how the process is going to work, because otherwise you end up with some quite nasty surprises sometimes. I'd say certainly in litigation where one's in foreign courts, the selection of local counsel is the most important thing that you do. And I see this very often. Often there's quite limited time because you might have been served with foreign proceedings that you're having to deal with to make that selection. But it really, really is as important a decision as anything else you do to try and get that local counsel choice right. There is, again, huge divergence within the jurisdictions that I've litigated abroad between the quality of counsel. And so really try and do as much getting referees, interviewing foreign counsel as you possibly can. And because often time is short, what I would say is, say you've got a contract with a difficult counterparty that's maybe governed by French courts. Don't wait till you get sued in the French courts before you start looking for a French lawyer. Do a little bit of research, do some reaching out to various French firms to try and have a sense of who you might use if you get this litigation sprung on you, rather than trying to find somebody. I mean, we see this in England. People will come to us and say, I've got 10 days to file a defence, what do I do? That's not a great way to be trying to select your counsel at the same time. I'd also say on that, be careful of go-to firms. There are some very big global law firms with a flag in every single jurisdiction. And it's quite easy if they're my law firm and they're a big player in say I always use X law firm in my home jurisdiction, to pick up the phone and say, have you got an Italy office? Well, look, they might have an Italy office, but it might be about the 15th best litigation office in Italy. So don't be too lazy about selecting local counsel, just going with a brand you know, because sometimes those brands are nowhere near as good in those foreign jurisdictions as they are in the one that you're used to dealing with. And actually, quite often, they are not the strongest offices in certain areas. The other thing I think is quite important when you're in international tribunals or you're in foreign courts is to really try and get a cultural understanding of what is driving the judge or the arbitral panel. Because unless you understand what they're looking for, you can't frame your case effectively. And there are big cultural differences for what judges and arbitrators are looking for. One example I see quite regularly acting for US clients in the English courts is US clients are used to jury trials. They like to throw as much dirt and mud and irrelevant accusation as possible at the other side, because that can influence a jury which is not necessarily that sophisticated. There is an automatic assumption that that kind of approach will work really well in front of an English court, because that's what we do in America all the time. That's going to alienate an English judge really, really badly if you're going off on a whole load of irrelevant points to the legal issues between the parties. So just try to be very, very conscious and get inside the mind of the arbitrators or the foreign judge to think what will work and frame your case accordingly. Don't have a one-size-fits-all approach. So just some learnings I want to talk about around issues that come up quite regularly where one has got cross-border disputes. And these are issues in domestic disputes, but I think they're emphasised when you've got a cross-border element. Witnesses and documentary evidence. In terms of documentary evidence, early preservation is really, really important. You may well have a branch office in a jurisdiction which could become quite hostile if you're suing the wrong people in that jurisdiction. So getting that evidence and preserving it is really, really important, both in terms of being able to show the tribunal or the court that you've taken the appropriate steps, because you're normally under obligations once the dispute becomes live to take those steps, but also to make sure that you've got the evidence that you need, because it might not be there forever. Things might happen, servers might get wiped, which contain very valuable information for your case. So really try and get onto that very early. Likewise, in terms of witnesses, if you've got solely UK proceedings with English witnesses and maybe it's an employee, frankly, if the employee leaves, it doesn't matter that much, because you're always going to be able to compel his attendance or her attendance. That's not a big challenge, because if you're called, you have to turn up. That's not necessarily the case if you've got a witness in Saudi Arabia and it's an English court case. Now, he may be friendly at the moment because there might be the guy who's running your office in Saudi Arabia, but you could fall out with him in 4 months or in 6 months, or he might decide he doesn't want to testify at the last minute. So try and get those proofs of evidence, detailed proofs of evidence, as early as possible, because even if it ends up that the witness in due course doesn't attend for some reason, or the witness dies, or something unforeseen happens, you can normally get that evidence in as hearsay, so at least you're getting that important witness evidence before the tribunal, before the court. One thing that certainly is, as common law lawyers, is sometimes slightly alien when one's in civil law jurisdictions, is that it can be quite hard to get disclosure compared to the approach that we're used to. And so a couple of thoughts on that. The first is that using investigatory agents can be a good way of getting around that, and that can be much more important in jurisdictions where you can't readily get disclosure. But always be careful, because there can be local laws which are contrary to that. So again, talk to your local council what's possible. The last thing you want to do is be gathering evidence in a way which is contrary to local law, which then alienates the local judge and makes you look not a legitimate counterparty. But the other thing is also to look at whether or not there's ways of getting disclosure in other jurisdictions. So we had a case, a few years ago, which was an English company and a French company, very odd jurisdiction clause. They basically got to choose between English or French courts, claimant's choice. And the French party started proceedings in France, and in order to defend those proceedings, we needed disclosure they weren't going to give to us. So we launched a claim in England, or before launching a claim, we went for pre-action disclosure in England. And the English court actually ruled that, yes, you can get pre-action disclosure in England if you're able to then bring the claim in England, which we could under the choice clause. And we then used that disclosure to defend the French proceedings, and we didn't actually launch the English proceedings. But it's worth taking quite a creative route, not just being bound in by where you're having the dispute, but looking at other jurisdictions where you might be able to get useful information. Next point about understanding the counterparty. Again, this is about avoiding one size fits all. Ultimately, what you probably want is a favourable settlement. You don't want to slog away through litigation or arbitration for 2-3 years and then get into enforcement. And there, tactically, it can be very important to try and get into the mind of the counterparty. And don't just assume that what would drive people to settle in your jurisdiction will drive that counterparty in their jurisdiction. So, for example, with Far Eastern clients, sort of saving face can be extremely important within their organisation, more so than maybe within an English or American organisation. So are there ways that you can frame a settlement or offer a settlement which enables that company to save face? If so, it may be much easier to get a deal out of them than if you are making it very, very accusatory and very aggressive and hostile, which might be an approach which would work well with a counterparty from a different culture, which would cause them to sort of respect you more and be more likely to come to the table. Finally, PR and media strategies. Some jurisdictions, the judges can be quite influenced by what they see in the newspapers and on the TV, and the same with arbitrators in certain jurisdictions. And so think very carefully about whether or not there's things you should be doing to influence the PR and the media story around your dispute. And that's not, some companies take the view that we don't really do that, it's a bit shady, it's not our kind of thing. Well, okay, that's a call, that's fair enough. But the other side might start doing that to you. And so how are you going to react to that? And in those circumstances, again, I think having a PR and media strategy, even if it's only defensive, is something that's worth doing, and particularly in a sort of cross-border context. Okay, so finally, cross-border disputes tend to be slower, more expensive, more onerous on the business in terms of time and resource, and by their very nature, less likely to result in the recovery of cash at the end of the process. And so it is really, really important if you're advising a client on a cross-border dispute or if you're in-house counsel on a cross-border dispute to make sure that the C-suite understands that and you have proper organizational buy-in. And again, this sort of goes back to the point at the beginning that where everyone's very revved up at the beginning of this, then that it may seem like you've got that buy-in. You may feel you don't have to worry about that. But 2 years later and $1 million later, they may be losing some enthusiasm. And it's important, and actually it's the best time to try and get organizational buy-in, to document that early on when the internal client, the external client is sort of revved up, rather than halfway through when they start turning around and saying, how have you got me into this situation where I've got another year to go and I'm losing enthusiasm for it. So hopefully those are some useful learnings. I hope it's not too much teaching grandma to suck eggs with this audience, but happy to take any questions later. Thank you.
Thank you. Thank you very much, Chris. So I said I will be the third speaker for this session, and my topic is about China recognition and enforcement of foreign arbitral awards in China. So that's how the background is. Where I understand that all basic principles or facts. What are these panel guests before me? They were talking about the basic principle and many good recommendations. I think it's common for all and also applicable for China-related business or disputes resolution. And what for China it is important. If we see today, and China has a very strong, where it's still, where it likely it remains strong in the economic growth, and outbound investment is very encouraged, politically driven. A lot of outbound investment from Chinese enterprises, both state-owned companies and private ones, and China at the same time remains as one of the most attractive locations for foreign direct investment. So that what we are dealing with is where Luther is itself is a law firm based in Shanghai, and I am based in Shanghai and Düsseldorf in Germany, and it's a German brand, but we are a local law firm registered with the Chinese Justice Department. That means we can do everything as a local practiced law firm, including litigation. That means actually for us, it's our daily business to deal with different cross-border contracts like license contract, like international trade contracts, investment contracts, joint venture contracts, and so on. And there are a lot of disputes, in fact, that we are dealing with since years. But what my experiences tell me, if we're in this group of us lawyers or experts, I think usually one can understand that a contract, if one contract has a good advisor, legal advisor to support, it is usually very, we expect that there will be workable clause for settlement of dispute, either court or arbitration. But in fact, as I noticed, when I just reviewed the most recent case, which I or my team has been dealing with in the past years, it is a bit surprising for me to see how where not every contract is made in sufficient quality. Even you see that the remaining part of the contract is made very well. It seems like a work by a very good qualified lawyer, either Chinese lawyer or another jurisdiction. But there are so many unlucky situations with the arbitration clause or with a clause with a settlement of dispute in general. If I recall the most recent examples that I or my team has experienced, there are two cases I can share with you as kind of examples. I talked with a colleague from New York Massive yesterday that we have been dealing a contract. The fact is that the subject of the contract and also the fact is rather transparent and not so complicated. It's American licensor and with a Chinese licensee, and the Chinese licensee is obligated to pay license fees. And after one or two installments, the Chinese party says, well, we have no money. We agree, we will pay, but we have no money. We are short of money. And the American party has to wait and wait and wait just until the American party is loses its patience and is considered to go legal ways. And we received the request to advise them. And when we see the contract, where the contract itself is perfect, but except the clause with a settlement of dispute. Yeah, because it's because the governing law provided for in this contract is the law of Florida. What does that mean? That means there will be a huge increase of costs and time expenditures, because China has no recognition mechanism of the court decision by another jurisdiction with most of the countries. There are a few, I believe, there are a few countries in which China remains such a relation, has a treaty, but with America, no. So that means for the client, either the client has to submit the lawsuit to American court and applies the law of Florida, and the court will most probably, I understand, I guess the court in America will most probably give a decision in favor of the client. But the problem is, you can understand, it will be very difficult for a Chinese court to enforce it. And there's another case we handled that is debt collection as well. It's internal trade, a supply contract, and the Chinese buyer is in a tier 1 city of China on the coast region, and the seller is an Austrian company. And when we see that the contract itself, it's nearly the same story. That the contract itself is very perfectly made, as we can see, and the arbitration clause is made as well. But unfortunately, I can understand why the arbitration clause provides for an arbitration institution in the city of China, and the name is not correct. And 2 Chinese characters or 1 word is added on the existing arbitration commission in this city, so that the said arbitration commission does not exist at all. So it took us nearly 1 year until to initiate the first procedure to let the Chinese court to give a decision whether this arbitration clause is valid, and it goes through. I will talk about it later in the later slides. There will be a procedure in China to see the arbitration clause, and it should be reported. There will be 3 instances until the Supreme People's Court in Beijing, until the final decision is made, saying where the arbitration clause is not valid. So that, but luckily the Austrian party as the supplier had got their money at the end, because the local court accepted this case, and because the fact is rather simple and transparent, just a lucky case for the client. Well, a bit about Luther. So China, it's a signatory state of the New York Convention since 1987, and you can imagine there are basic principles that are all applicable in China, where China is actually doing a lot of improvement since 10 or 15 years, so that you can always expect, with regard to international treaties in the economic and trade investment sectors, you can always expect that. At least from my experiences in the group of my clients, I understand it's rather a fair treatment, unlike many media says, unlike what Mr. Donald Trump says and threats. Actually, I received a quite positive feedback from the group of my clients, saying where it's fair treated, and it's and with regard to international treaty, Chinese courts are very cautious and very careful, so that in order that they do not make mistake. And China is a region where China has different jurisdiction. One country, there's a term Greater China, where Greater China includes actually in the economic meaning 4 parts. That is mainland China, where the People's Republic of China, the mainland part, Hong Kong, special administrative region, which is has a very very deep impact by the UK as the former colony of UK, so that the jurisdiction in Hong Kong is a copy of the UK one, common law, and the Macau administrative region, and where it is again a civil law region, and Portuguese is until today one of the official languages for courts in Macau and within the territory of China. In Macau. And the other part is Taiwan. Taiwan has its own jurisdiction as well, so that if we talk about Greater China, there would be 4 different jurisdictions. And inter-regional treatment between these 4 regions, luckily there are treatment, there are treaties between these regions, so that arbitration arbitral award made, for example, in Hong Kong by Hong Kong International Arbitration Center, for example, that will be easily recognized and enforced in mainland China, so as arbitral award made in Macau, but also in Taiwan, so that the bilateral regional treaties are well made and are well implemented. For you as European, for us as European advisors or enterprises, it may become an advantage for many for providing for arbitration clause, for example, because it happens very often if you negotiate with the Chinese contract party. The Chinese counterparty says, well, we do not accept, let's say, arbitration clause in Stockholm or Vienna or anywhere else because it's so far away and we are not familiar with that and the costs are high. And it's the same opinion by the European party. So it happens very often that the parties agree on arbitration clause by using Hong Kong International Arbitration Commission as the arbitration body, so that because Hong Kong is also well known for its transparent, for its ranks very top on the transparency, on the non and compliance worldwide, and it's trustable, and the cost for both, especially for the Chinese party, may be not so high. And the Hong Kong International Arbitration Commission has a lot of arbitrators that are familiar with Chinese law, with foreign laws, and you can find generally every kind of arbitrator with language capabilities and background with different jurisdictions. The procedure for Chinese recognition and enforcement of foreign arbitral award, it looks like this. If you have received an arbitral award from an arbitration commission somewhere outside China, and you will have to prepare documentation. You have to prepare the application and submit it to our local court. Well, the China court system, the Chinese court has 3 instances. It's the local court, where you can generally expect, for example, in every urban district, like if we say Chelsea or Westminster, some district like this, every such urban district has 1 local court. So that means, for example, for Beijing or Shanghai, where it's a huge city with more than 20 different districts, there will be 20 local courts on this level. But for recognition and enforcement of a foreign arbitral award, responsible is not the local court, but one upper level, that is the so-called intermediate court. And each city has generally 1 intermediate court, but in Shanghai and Beijing there are more, 2 or 3. And the court will review, after the court receives the documentation, it will review whether the form requests are satisfied, and there is a list of the documents you have to submit. We will go through that later. And then review a procedure for the court to review and the counterparty. That means the award debtor will receive a copy of the application, and there will be hearing and so that means the the award debtor will have opportunities to object, to raise its grounds if he thinks that a certain grounds provided under the New York Convention should apply, so that this application should be rejected. There will be hearings, there will be negotiations, and and for the court, if the court itself believes that this application should be accepted and should be recognized, it should make such decision in principle within 2 months. But you can imagine 2 months, it's a time limit that is very often exceeded because the Chinese courts are, well, it's the same problem like worldwide, and the Chinese courts and the judges are very overloaded. So, and after this intermediate court gives its approval on this application, the applicant can apply for enforcement, or one can apply for the both when submitting the documents, the application to the court. But what if the intermediate court has the opinion that there's a certain ground to reject the application? Then there will be a de facto 3-instance procedure. So that means that there will be internal report. As I said, that is for the reason that the court must be very cautious before the other signatories of the international convention, in order that to make sure that they make no mistake. There will be internal report from the intermediate court to the upper level court. That's a higher court. High court. There is one high court in each province. There are more than 33 or 34 provinces in China, and each province has a high court. And a high court will review it, and if the high court believes it can be approved, then it will give green light to the first instance and say, well, intermediate court, you may approve it. Then an approval will be issued. And if the high court holds the same opinion and says, well, we have doubt, there may be a ground that we should reject this application, then it's the obligation of the High Court as well to report it internally to the Supreme People's Court in Beijing, so the highest court. And the court of Beijing will review it until it gives the final decision. So that means under some cases there may be even an advantage for the applicant if you think we'll use foreign arbitration commission, so that you can make sure that there will be a different instance, 3 instances, to make sure that your rights can be protected better than by local court if you go a normal lawsuit way, where the courts in China are well known for their overloading, and the corruption is always a problem, but also local protectionism, because the local courts, they are instructed somehow more or less to protect the local taxpayers, so that one can sometimes have the impression that local courts may do some decision in more favor to the local enterprises. So the time limit, until when, if you have got an arbitral award, let's say from an arbitration commission somewhere outside China, how long time do you have to submit to the Chinese to a Chinese court for to apply for enforcement? Where you have 2 years, starting from the date when starting from the last date when the award debtor is obligated to perform his obligations under the arbitral award. There are generally 2 years. It seems short, but since last year there is a new civil code in China. The new civil code has revised all general limitation period of limitation from 2 years to 3 years. So far, this 2 years limited under the recognition procedure of foreign arbitral award is not changed yet, but who knows? We may expect that it may happen. May be changed in the coming years. And there are very strict documentary requests if you prepare for application. And there are many documents that you need to have it translated into Chinese. And you should observe the notarization and legalization request. But in general, the procedure document requests are a bit less complicated or less demanding than the court procedure. So there are a list of facts and figures. So how many days a PLC court will take is quite long, even though it is prescribed by law that within 2 months when the first instance court should make decision. But even if the first instance court will approve the application, it takes an average 360 days. And if there's a final rejection, and if it triggers an internal report system until the final decision by the Supreme People's Court, it will take more than 500 days in average, according to our own statistic. And 50% of the proposals made by the first instance court will be rejected or approved by the higher court. And what's interesting for us is, in particular, if you see if we count for which legal ground the recent 10 years, for which reason the Chinese courts have rejected an application to recognize or enforce an foreign arbitral award. On top is the legal ground with the invalidity of arbitration agreement. So that's for me a bit surprisingly. As I said, I expect actually that if you are drawing up a contract with for your client, and if you have carefully studied the situation or the facts about the Chinese party, or if you involve your Chinese lawyer colleagues in time, what I had expected is actually this is not a big problem. At least a problem that can be easily avoided if there is a careful study, co-work with Chinese lawyers.
And I'm sorry, but it's really pleasantly surprising that violating public policy is not on top. Because in Russia, every time they refuse to enforce it, well, very often it's violation of public policy. Public policy is something they stretch, I mean the Russian courts stretch, go very far.
Yeah, it's true. It's true. Thanks for the comment. It also reminds me of some facts about China, because in China, the right or the power to give decisions in the first instance is intermediate court at local level, and sometimes you may also expect that the judges there are not really very experienced as you expect. So that until the early or mid of the 1990s, there were really the same problem, that there were cases where the local intermediate court uses or tend to use this public policy ground to refuse recognition by foreign arbitral award in order to protect the local enterprises' interests. So fortunately, actually, several of these cases were corrected by the Supreme People's Court with the explanation that we should narrow the interpretation of the public policy. So generally, you can expect that in China, the applicable principle is to narrow the applicable or interpretation of public policy. So,
I'm sorry, just about the public
please.
Policy. Do Chinese courts have two concepts of public policy? For instance, in France, the courts have the public policy itself, which is applied in domestic cases, and then they have the international public policy, which they apply to the international awards, actually.
So I understand if we are talking about in the Chinese jurisdiction in circumstance, if we are talking about public policy, it's rather Chinese domestic ones. So if, for example, as I said, there's a Greater China region, so there is so far it's not happened, but I can imagine or by comparing by similar administrative procedures. For example, if arbitrary award made outside China says, where if you can read in this text that Taiwan is somehow recognized as an independent country, I can imagine that this application will be rejected because and by referring to this public order policy. So challenges. What is especially in China, where one should keep in mind that there's a short period of limitation until now, 2 years, and there are very strict documentary form requests and long duration for processing, and practical difficulties enforcement. Where in China there is a practice that the experiences tell me that about 50% of enforcement applications are fruitless. That is because China has that is not only applicable for the topic what we are talking about, but also it's the same for domestic disputes or domestic applications for enforcement by court. Yeah, it's because because the social credit system in China is not so established so far, and there are many risks that the award debtor may hide its assets, and there are not so transparent controls of the assets or bank accounts, and there are no legal ways or less legal ways for the applicant to collect evidence in a way that where the result can be recognized by court. So a few practical tips, for example, recommendations. Before entering a contract with your Chinese contract party, I think it is worthy to review the topics. One, whether or not the dispute can be arbitratable. I think, because China has a reservation as a commercial reservation that only commercial matters, only award on commercial disputes can be accepted. Lawsuit or arbitration, as we said, arbitration and litigation, these two ways, they have their respective pros and cons. There's no one size for all solution, so that must be reviewed case by case. And if you agree on an arbitration clause, that is also one of the essential issues if you choose a Chinese arbitration commission or a foreign one. As I said, Chinese arbitration commission may have the advantage that the duration may be shorter, because there will be no complicated and long-lasting procedure for recognizing and enforcing a foreign or arbitral award. And you may want to approach, for example, the CIATIC, the China International Economic and Trade Arbitration Commission, which is also one of the where it has rather good reputation, and also Shanghai International Arbitration Center, for example. And China is also improving its hub as arbitration hub for international business disputes. There are many efforts made. And convenience factor, so that's the same for all. And before I enter, and other factors that we have to take care to make sure is, let's say, a seat of arbitration, governing law, and so on. I think also this is a common issue for all arbitration procedures or contracts. And after that, you may need to observe strictly all procedural requests if the Chinese contract party refuse to do other arbitral award orders. You may prepare for an enforcement, and before the enforcement, you may have to go through the reclamation procedure if the arbitral award is made by a foreign arbitral body. Itemize arbitral claims. This is also important, so that in the end the court may, for example, reject a part of the items request and while recognize the remaining ones. That can also happen. As I said, enforcement is difficult. there's a procedure that is where the Chinese legal system is always somehow comparable like the civil law in Germany, because China copied the civil code from Japan, and Japan copied the same from Germany. There are basic, very huge. There are common problems with enforcement because you don't have the access to the data of the assets enforceable. So that means actually, in the end, what I would say is where one of our speakers yesterday shared the same opinion that the best solution is that to avoid dispute. That means at the very beginning, when you prepare a contract, you should consider about how to avoid dispute, like request sufficient securities on your delivery, on your rights. There is a case study. I would not go into details for today. And if you have questions, I would be pleased to talk in the coffee break. Thank you all.
Actually, I have a question about the avoiding disputes by the Chinese parties. So it's a common, not knowledge, but probably common idea that the Chinese culture, people and lawyers try to avoid disputes. So what's, from your point of view, the percentage of the disputes which really go to arbitration or dispute resolution? And can you confirm that there are long negotiations from the Chinese parties before going to dispute resolution, actually?
Well, actually, yes, because it's interesting or funny. If you see a typical Chinese contract, in nearly every Chinese contract that a Chinese party provides or is drafted by its lawyers, it may contain one clause. So every party should take up friendly negotiations if there's any disputes.
So it's formulated in this way.
So it's formulated in this way. You can see, I believe you can see this sentence in nearly 80 or 90% of a contract made by a Chinese party or lawyer. So it is traditional that negotiations can be made, and the Chinese parties are traditionally, Chinese individual persons or companies, they are very resistant against lawyers because the traditional Chinese cultures believe lawyer is someone that you actually do not need until there is a dispute.
Related to this point, you mentioned corruption and lack of independence
Yes.
as a problem
Yes.
in the Chinese judiciary. Are you aware of any significant award that would have been enforced against the Chinese party?
And a
A
significant.
significant monetary award that would have been enforced against the Chinese party?
In Chinese courts.
In Chinese court, well, actually, yes. I mean, corruption. There is corruption, but if we see the lawsuits, if we see the litigation procedure, so generally can expect that the treatment is rather fair if there's no political background, if there's no sensitive topic background. That means, for example, environmental factor. If you are going to sue a certain company that has caused certain pollution, and this company is one of the biggest taxpayers, unless for these circumstances where there's an interest for the court itself, one can expect that it's relatively fair that you receive justified court decision. And for arbitration, it's in particular recommendable because arbitration that is, with arbitration, you can avoid that the case is handled by the courts, by the judges. Where
Not if you have to enforce the award, right? If you win the arbitration and your counterpart doesn't comply voluntarily, then you need to go to the court.
Yes, you need to
enforce
go to the
law.
court. That is what my case study where it tells the story that we have been handling a recognition procedure and enforcement procedure since 2013 until now. It is not finished yet. That is because the local court does really give some obstacles where we can notice it's because it's a joint venture dispute and the foreign party. The foreign party is, has applied for the dissolution of this joint venture because of a breach by the Chinese party, and they won the arbitral award in Vienna, made by VIAC. So the local court, where we can see there's no essential legal ground for the court, local court to say because they approve it. They did not refuse it, but while the enforcement, you can see there are different tricks that you believe that you can believe that somebody is stands behind and tries to monitor the procedure to at least to cause a delay or just let you wait. That can also happen. Not easy. China is not an easy country.
Is there any more questions?
I have one comment actually. So at the beginning we talked about avoiding disputes, and it's very interesting to look at different cultural behavior, right? So just for you, if you're ever interested in Russian negotiation style, there's a very interesting paper, EU diplomacy, called Negotiating with Russian Bear. It's available on internet, just type it. And it's very, very interesting and proper description of Russian negotiation style. As we were saying that Chinese are not aggressive, Russians may become very quickly very aggressive, but at the same time they have these Asian features, so they will be afraid of strength somehow, but they're very, very strong at negotiating at the same time on backstage. So if they're aggressive before you, it doesn't mean that they won't do something behind your back. So if you're interested, it's very, very interesting and proper paper to read. Very short as well.
Thank you. I think we need coffee break.
Yeah, I feel we still have questions, but it's just not coming onto their mind because we all need coffee break. So before we go for the coffee break, I would request Mr. Liao Yuhui to present the memento to the speakers. No name.
This is? No name. Okay. So thank you very much.
Thank you. I didn't expect that.
Chris?
Thank you.
Maybe I gave
Yeah, for me. Thank you very much.